I can do what I want when I want to do it. I can do what I need when I need to get through it. When I need someone else, can't be too proud for help, but gotta look after myself. Sometimes it can get lonely, never living in the moment. When the sun is shining, hope that I'm like how the clouds keep changing. I'm always steady rearranging, going back to the basics of what a good day is. What a good day is. And that's exactly what the day is, but it's exactly what you make it. So please don't go wasting, and I'll do the same, even if it's raining. How could I complain? And my feels got me feeling some type of way. You always free to take a break. Hope you feel what I felt. You gotta look after yourself. Sometimes it can get lonely, never living in the moment. When the sun is shining, hope that I'm reminded. Like how the clouds keep changing, I'm always steady rearranging, going back to the basics of what a good day is. Of what a good day is. What a good day is. And that's exactly what the day is.
All right, it is that time. Y'all know what to do. Drop a 1 in the chat if you can hear me. Drop a 1 in the chat if you can see me. We're gonna get into it, and we should be looking nice. Oh, wee, looking all crispy and clean on the screen. We should be good. Welcome, y'all. Welcome back to another YouTube live stream and another episode of the Music Morning Show. I'm your host, ClassE Beats at ClassEbeats.com, and today we're going to get into it. We've got an update from Joe Tacopina and what's going on with the civil lawsuit after the A$AP Rocky trial, and a little bit of what went on during the trial. We've got an exclusive interview that he did with TMZ. We're going to cover that. We'll also get into YNW Melly and see what's going on there. He recently had a court date, and there's a lot of updates in that trial. We've been covering it since the retrial. I'll give you guys a little bit of a background on what's going there as well. But before I get into it, I gotta say what's up to the people, man. Shout out to everybody who's in the building. Of course, y'all know my awesome, amazing Amy is in the building. Shout out to Amy, man. Thank you, Amy, for everything that you do. I love and appreciate you. We got Michi up in here. Les Cleaver is in the building. A Fitz, J Buckmaster. We got Shadow Fox 9224 Valencia is in here. Power Folks Living. Peter Steele, Miss 86. Good morning. The Honorable Attorney Cal Bell is up in here. Libby SC22 girl is in the building as well. Or Libby 22 SC girl, excuse me. I said it backward. We got Ryan S in the building. Good morning. Good morning to you. Serotonin is up in here as well. And shout out to Laura C as well. Yeah, she said the YNW Melly case is a mess. We're going to get into it. We've been covering it a little bit since a lot of these motions have come out. We covered the first motion hearing they had since the initial trial ended. That was a mess. And now Judge Fein is going back and forth with the state, mainly because they're just prolonging this thing. That poor man has been in jail nearly a third of his life, which is absolutely insane at this point. It's really sad to see 222 days or 2,200 days or something like that. We'll cover it here in a second, but yes, this whole case is a mess. Absolutely a mess. If y'all could do me a favor, make sure you like the video on your way in. Not only is it free, it takes 2 seconds, and it does help the channel continue to grow. Lets the algorithm know you guys are enjoying the show, and it shares the video with more people. So if y'all could take a second to do that, I would appreciate it. I also have to read some of these super chats, man. Shout out to Michi in the building with the 10 bomb to start the day. And I will be reading super chats throughout the show. Thank you so much. Michi says, good morning, CEB family. It's a beautiful day. ClassE 110K is on the way. Sheesh. I'm going to claim it, Michi. Thank you. Thanks for being you and providing a great place on YouTube to come and have a good time. Free Yak Gotti. Yeah, well, hopefully we'll have some updates about Yak Gotti here shortly over the next couple of days. But thank you for being here, Michi. You continue to support, been a member for a long time here, and show up every single day to support the show. So I gotta give you another round of applause for that. Thank you for everybody that's in here too. Shout out to Michelle. Says, I got used to listening to you and watching you through the Rocky trial that now I'm just here for whatever you have to offer as a part of my daily routine. Glad to hear it. Hey, we've got some great news for you. So we're going to get into it. Again, thank you to everybody who's in the building. Let's go ahead and get started with this first one from our guy, Joe Tacopina. Y'all are calling him ASAP Joe, ASAP Taco. Let's see what he's talking about. So recently, Joe Tacopina did an exclusive interview with TMZ, where he actually gets into some of the things that were happening behind the scenes, and specifically what he heard or what he was seeing from the jury. It's going to be an interesting perspective, as we didn't get to hear a lot from him during the trial because Judge Arnold said, y'all ain't talking to anybody during the trial. So you're just going to have to wait and get it all out of your system then. So shout out to TMZ for this. I'm going to leave a link to this video in the description. Not going to play the whole thing, but we definitely want to hear what Joe's talking about.
Joining us right now is Joe Tacopina, the conquering attorney in this case. Joe,
Morning,
welcome
Pocket
back
Bully.
to TMZ Live.
Thanks, Harvey. Thanks, Charles.
Okay, so two things. One, congratulations, and two, you look like you got no sleep.
Wow, right off
He
the
said,
bat,
"You look
Harvey,
terrible."
just hit him with that. I mean, he's right, though.
Harvey.
I mean, he's right,
A month
though.
of no sleep. A month of no sleep, and then last night was a little rough. I don't really think I'm in condition to be on television right now, but I'll give it a whirl. No, but it's been a month of no sleep. I mean, look at me. It's tough. Trials like this are crazy because you don't sleep. You know, even when you're done working at 3 or 4 in the morning. You know, I sleep with one eye open and a pad next to my bed because I'm always thinking of something and my brain doesn't stop. So it's not really.
Yeah, it's got to be crazy.
You go on adrenaline. You literally go on adrenaline during the day. I did a 5.5 hour summation on no sleep, but it's adrenaline. And then after the trial, it all goes crashing down. But it was worth it. I mean, it was such a beautiful day yesterday because those two people mean so much to me. Last night was a really a great night of relief and happiness for them. And of course, for me too. And,
What were you, Joe? What were you thinking at that moment when Rocky first? There was a quick congratulatory hug, and then the crowd surfing. What were you thinking at that moment when he walked away from you?
Yo, Rocky was all over the place, man.
Into the gallery
well.
there. Were you thinking the judge isn't going to like this, or good for him, or what was going through your mind?
The judge loved him, so it wasn't even that. Here's what was going through my mind. When there's a verdict being read, I'm laser focused on that clerk because there were 2 counts in this case. And even though I was confident, I came on your show the day before the verdict, right? I said how confident I was, which a lot of people were like, oh my God, how can you be so confident? I was like, because I am. But
we all were confident, Joe.
Counts, and the jury could do anything. And so I wanted to hear a second not guilty before we started hugging. You don't notice I didn't move. I didn't see Rocky leave. So I'm laser focused. I turned to him and he wasn't there. And I said to my partner, Chad, I go, did he leave? I look back and I see him body surfing in the audience. Like, what? I couldn't process this, guys.
All you saw was the bottom of his shoes.
You know the funny part of this is when you.
And we mentioned it too, because we were like, man, what if the second count was guilty? Boy, that would have been super awkward. But the odds of them saying not guilty on the first one and guilty on the second one were highly unlikely, but that would have been wild for sure.
You look at it again. The bailiff was helping him over the banister. I mean, see the woman now? What? She takes his feet and she helps him over.
As long as he's going over, let's make sure he gets over all the way.
It was great, that bailiff. But anyway, so I didn't see it. Then like,
that's funny.
Get him back here. We have another count. And then I'm thinking, my God, how embarrassing would this be if they find him guilty on the second count, right?
Oh,
right.
I knew that wasn't going to happen. But everything goes through my head when I'm hearing a jury verdict. The tension is insane. Like the anxiety. This is the worst part of my job for sure. Waiting for that, they say hours of boredom, seconds of terror when you're waiting for a verdict and then you hear there is a verdict. And so listening to that. And then so finally, when both counts of not guilty were read, then it was just pure elation and joy. And then, Rihanna gave me well, he obviously see Rocky there give me a massive hug. I couldn't breathe almost. I think right about then I was like, I can't breathe. So yeah, that was
It
a
really,
chokehold right there.
it really did look like family, Joe. And I know we talked about this on Monday, where you
Yeah,
say
that's
that
awesome.
you think of your clients as family, and they've said the same. But that hug, that's what I was thinking when I saw you guys celebrating that way. I was like, wow, that is a family hug right there.
Yeah.
It is. It is. Those two are special to me. We've been very close for 3+ years. I can't tell you how many times I had to convince them and reassure them that it was going to be okay. I mean, Rihanna, I've had a lot of one-offs with her where she's like, Joe, is my family okay? Is my family? I said, yes, you're going to be okay. We're going to be okay here. She gave me one of the strongest hugs I've ever had in my life. And you notice the suit I chose to wear, that there was a sort of a light colored beige suit. She gave me this massive hug. And when she lifted her head off me, I noticed I had the whole Fenty collection on my lapel.
Shout out to Joe.
I went from a pure elation of a not guilty.
Hey, by the way, that suit coat is probably worth a lot of money.
That's right.
You can put
100%. Put it on eBay, dude.
Really distraught.
That's funny.
I just was like a brand new suit. I was like, so I said last night I couldn't help myself. Rihanna, did I talk to you? So she's like, Joe.
Joe, you're reading it wrong. We're saying it's worth more now
No,
that it has
it's worth a ton.
Rihanna's makeup on it.
This is worth thousands and thousands of dollars, Joe.
Yeah, that's
Oh,
true.
sell that thing.
Thousands
Yeah,
of
because-
Oh, you hear that? He's like, what do you think I buy, Harvey?
I thought it was like I thought it was a $300 suit, Joe.
That's funny.
The thing that is really stunning about this is turning down that plea deal where you would have gotten 6 months, and
Right.
you're rolling the dice on 24 years, and you won it. So that's great. Now, the question that everybody has, certainly in our office, is an interview, a post-verdict interview.
One of the jurors.
One of the jurors gave.
Yep.
And what this juror said is a little bit confusing to us.
When
Now,
you
here we
heard
go.
the idea of the prop gun, just you personally, what'd you think about that?
I didn't really believe it. I didn't think that either, that they had really convincing evidence that it was a prop gun. It was kind of a little mysterious the way it was prepared, and they couldn't produce it, as evidence. So some of the testimony did not sound accurate or truthful.
What did you think about the testimony of Relly?
Really, I believe so. I believe that he felt his life was in danger. I do. I feel for all of them. All the people involved with this. I feel like this could have been avoided. I hope
That's
that
true.
In the future,
That's a good point.
Mr. Mayers really thinks his actions. About his actions before. He is upset with somebody. He does have a lot to lose. And he's lucky at this point that we didn't have enough evidence to hand down a conviction.
Joe.
Wow, she said he's lucky we didn't have enough evidence to hand down a conviction, which is what we were saying throughout this entire trial in the first place. But it's interesting to see that they mentioned at TMZ him possibly taking the plea deal, which would have been 6 months in jail. It's a lot of time if you've never been in jail before. And then, of course, he would have had the probation and a felony. And I looked up to see if California does have a first offenders rule like they do here in Georgia, to where if you're a first offender, you can maybe do a certain amount of time in your probation, and then that felony kind of falls off depending on the felony. But even in this instance, with it being a felony he would be agreeing to, which is assault with a semi-automatic firearm, the first offenders might not even apply, even if he were here in Georgia, which is, again, interesting.
She also said that they believed a crime had been committed. And you heard her say they didn't buy that, your theory that it was a prop gun. So we heard all that. And we're like, well, wait a second.
A little confusing.
Why didn't they convict him then?
Well, one, that shows me the system works because there's still a reasonable doubt. I focused heavily in my summation on a reasonable doubt. I said it only takes one.
Smart move.
Look, here's what a reasonable doubt is not. It's not he probably committed the crime. It's not I think he committed the crime. It's not he most likely committed the crime. It's not I'm almost certain he committed the crime, guys. It's I have no reason to doubt he committed the crime. That's the highest standard the law permits here.
Right.
And that's a very high standard. You just heard her. That standard wasn't even close to being met. Now, I will say this. I spoke to 3 other jurors, had completely different opinions than she did, who believed that the evidence was as strong for a prop gun than a real gun. It couldn't have been a real gun if there was no evidence of a shooting, which their lead detective said. There was no shell casings that were recovered by the police.
Right.
I could go on and on. I don't need to give my summation again. But so 3, here's what she also said in the beginning of that interview, which wasn't played here, was she said they went into the jury room and it was a 10 people wanted to vote not guilty right off the bat.
Yeah, she said that she and like one other person needed.
Right. Yeah, and shout out to Nick at Night. They did give her credit for this. So Nick at Night has the full interview. If y'all haven't watched that, make sure you watch it. I'll leave the link in the description to that video as well. But hey, shout out to the content creators out here getting some shine, doing their thing. But she did mention that the majority of them believed already it was not guilty. Now, for what reason they said not guilty may have been different from what the juror that was interviewed by Nick said. I find it hard to believe that people were struggling with the prop gun theory. The more and more I thought about it, it didn't seem like a theory to me. It seemed like Rocky didn't want the liability of having a real gun on the streets, and maybe he just didn't trust himself to do what he's supposed to do, and rightfully so, because he did fire 2 whatever blank shots, real shots, whatever you want to call them. So in my opinion, he made the right call if it is a prop gun, and we still don't know where those shell casings came from that really quote unquote found either.
She was always our problematic juror. We knew that going in, just by our faces and everything else. And that's the one that
there's always one. I told y'all.
It only took her 3 hours to be convinced to come around, right? So when she says we thought of crap, I don't think she speaks for that jury, because I spoke to 3 of them. And Nancy Dillon from Rolling Stone also spoke to another juror who had a completely different take on this thing, and she published that interview. I spoke to 3 jurors who reached out to me and said, look, we're so happy for him. Please pass on our regards and let him know that we believed him and we believed in him, and we're happy for him. So look, when you have a jury, you don't know exactly what's going on back there, right? And it's just
that kind of brings me to something that I've always wondered about. So you get a call that the jury's reached a verdict, and it was a little less than 4 hours. So
3 hours and 5 minutes.
Yeah, so that. I'm sure Rihanna and ASAP asked you at some point, what does it mean? What do you say to them before the verdict?
Yeah.
Do you create a sense of confidence? Are you cautious? What did you say? Did they ask that? And what'd you say?
Yes, of course they asked it. And I said what I felt. Look, I don't ever
Neek like Monique. Oh, okay, cool.
In a moment like this, when it's just the consequences are so dire. And so I said to them what I felt. And what I said to you guys the day before, I said, look, guys, we had a 4-week trial. We have very smart jurors. We had like a rocket scientist on that jury, a rocket scientist. I'm literally a rocket scientist, like a scientist who builds rocket ships.
Wow.
On that jury. Okay? For real, I never met a rocket scientist before. She was on our jury.
Well, you're not talking to here.
or here. We're all in that same club. So anyway, I said we have a super smart jury. Reasonable doubt was, it larged this case. There's hundreds of reasonable doubts. All they need is one. And so, I said, there's no way 12 jurors came together in 3+ hours and found you guilty. There's no way. We're getting acquitted. This is going to be behind you. Now, that's what I believed. Of course, that being said, you just never know.
Yeah, that's true.
And the judge is something very unique here that almost did give me a heart attack. I think I've lost a couple of years of my life.
When he polled the jury before the verdict?
Harvey. So I've tried 120 jury trials, both as a prosecutor and defense attorney. You never poll a jury.
I know. I felt the same way. I know.
No, it's never happened in my career.
I was shocked.
Yeah, that was wild.
You don't poll a jury on not guilty. He gets the verdict forms. First of all, you read the verdict first, then you poll the jury on a guilty verdict. He gets the verdict forms. He looked angry. And I'm like, oh my gosh. And I know he liked Rocky as a person. And he made it clear he liked Rocky as a person. He looked upset. He turns him down and he says, I want the jurors to be polled. I want them to all acknowledge openly that is their verdict.
Dang.
Like, are you kidding me? I'm like, how
that would have been
There's no
scary.
way those 12 jurors convicted. There's no way. It's impossible. I told you guys that the night before. Yeah. And I was just like, I can't believe this. For the first time, I started feeling lightheaded. So I looked over to our local counsel, Sarah Kaplan, who was there. And I said, Sarah, do they do this in California? And she said, never.
I know.
Oh my God.
I know.
Rocky, now Rocky's here listening to all this, and he looks at me.
I told you this.
He goes, oh, literally, that's what Rocky said to me. I'm like, hang in, let's see.
Dang.
But I really thought we had a problem. I really did. And then afterwards, I went to the judge. I said, hey, Your Honor, on the side, I said, what? What did you do? Did I need that?
What do you say? What do you say?
I do that in every case. I go, you poll a jury on a not guilty in every case? You go, why? Because I just want to make sure it's their verdict. I'm like, okay, well, you should have read the not guilty part first. Because you owe me a few years. I said,
boy, that must have been
but anyway,
unnerving.
That was a moment, guys, where I felt ill. I felt really ill.
Right, especially after
when it happened. Yeah. But
well, now we know why there was that explosive reaction because
from Rocky, right? Because he had a moment there where he's like,
thinking, oh
this
my
is
God,
going
I'm
south.
screwed.
Hey, was there
That's crazy, man. Hey, congratulations again to Joe, ASAP Rocky. I'm not going to play the rest of the video. I want y'all to go support TMZ for getting this exclusive interview. I will put the link to this video in the description. Let me know what y'all think about this, man. So many wild things happened throughout this trial, and it's interesting to hear what Joe's version of what the jury said to him versus what the one juror said. As I mentioned to y'all, I've served on a grand jury before. There's always going to be that one person that's folding their arms and wants to either be contrarian or they really do believe against what everybody else is saying. And you've got to either convince them, you have to further explain things, why you're seeing it a certain way. So sounds like it went down to the wire in some cases, and it was just a very weird situation. Either way, let me know what y'all think in the comments and in the chat. Shout out to everybody that's in here too. Thank y'all for liking the video. Nearly 100% of you have liked the video so far. I appreciate y'all. I know we've got a couple super chats I want to read in here before we get into YNW Melly as well. Never seen that happen in any case I've seen. Yep, I see that for sure. I've never seen that in my life. It was bizarre. I wonder what, maybe we need to interview Judge Arnold and see why he did that. He told Joe, he's just like, oh, I do that in every one of my cases. And according to his local counsel there, they said, no, he does not. Shout out to Michelle Williams in the building, dropping the super sticker with the unicorn. Thank you so much, Michelle. I appreciate the love. We've also got Sean Street in here with the 5-bomb. He says, can you report on this? Case number 25 CCP 1262, Jay-Z Jack Dorsey. Yeah, that's probably, you're probably referring to this, this one where Jay-Z's being sued by a board member, I believe. We're going to get into that. I don't want to report on it right now because we don't have all the information, but I'm going to get the full document for y'all and we will be covering that tomorrow. But yeah, it's looking like Jay-Z is being sued. Let's see. He's being sued by Jack Dorsey. No, he's being sued by Viraj Patel over at Block. Jay-Z, a Block Inc. board member, is accused of SEC violations, breach of fiduciary duty, aiding and abetting said breach, unjust enrichment, abuse of control, and waste of corporate assets. Basically, what they're saying is Jay-Z spent money on stuff that he wasn't supposed to. So we'll get into that tomorrow once I get more information about it. But yeah, y'all stay tuned for that. Jay-Z back at it again. We've also got Alejandra in here with the 2-bomb, says best show ever. Hey, thank you, Alejandra. We're trying. We're doing the work over here. I appreciate the love. And Kel Bell, the Honorable Attorney Kel Bell, says the jury member's statements are terrifying. Think of how close to a conviction or a hung jury he was. Man. 6 months versus 24 years. That's what you got to be thinking about. It's crazy. I knew something is coming for Jay-Z. He can't run from God forever. You haven't even, dang, Miss 86, you haven't even seen the lawsuit. And y'all are saying, yeah, we got him. Why do y'all want to see Jay-Z go down so bad? And this lawsuit is 52 pages. Oh my gosh. Tell you what, while we're going through YNW Melly, I'll do some more research and see if I can find the full thing. This one is probably going to be not as exciting. Just because it seems like more of a Fannie Willis type situation, but we'll get into it and I'll give y'all an update. Shout out to Jay-Z in the building, says she didn't do it. Good to see you back in here, Jay-Z. All right. Not that Jay-Z. It's Jayz. Shout out to Jay-Z in the chat. Libby says she's scared of YNW Melly. Oh, man. Well, we're going to talk about YNW Melly here real quick. And I want to give you guys a little bit of a rewind if you're not familiar with the case. So that way I can we can break it down a little bit. So let's get this video ready. And thank you again to everyone that's liked the video so far. All right. So let me hold on a second. We got a couple more super chats. Shout out to, speaking of, Jay-Z in the building, said my ears are ringing. Shout out to Jay-Z. It's been a minute. Good to see you over here, though. And thank you for the 2-bomb. I kept saying Jay-Z too much. Not that Jay-Z. Jay-Z. Appreciate you being here. Melly's been done dirty. That man has been sitting in jail. I said a third. I can't remember if it's a third or a fourth of his life. I think it's a third of his life, which is crazy. Always believe in yourself. When you know you're not guilty, say it and take it to trial. There's a lot of innocent people in jail now, like Yak Gotti. I don't know if I'm willing to take that risk. I'm going to be honest with y'all. You can call me a coward, call me weak, whatever you want to. I have a family. I have people around me that I love, I want to spend time with. I have a life I want to live. And if you're saying, hey, you believe you're not guilty, and what you're going to have to do is you're going to have to go before these 12 random people, and you're going to have to present your case. And then somebody else is going to present a case saying that you're actually guilty. And you're going to have to hope that these people see it your way and believe you're not guilty. I don't trust anybody that much. It's tough. It's a tough situation to be in. And even with Yak Gotti, not guilty on all counts, he got into jail. He did something while he was in jail, and now he's still sitting there because of what he did when he was locked up, even though he was innocent. So, I mean, what do you do? I think you don't know until you're in the situation. Because someone mentioned Tory Lanez the other day. We saw Tory Lanez. He went to trial. He believed he was innocent. He fought it. He's sitting in jail. We see in the ASAP Rocky case, I mean, we have more evidence for this than we did for Tory Lanez, and ASAP Rocky's going free. So it's like, how do you never know which way it's going to go. You never know. Young Thug was just around the wrong people, and he sat in jail for years. I don't know. I don't know if I can agree with that, because you're putting a lot at stake. What are you going to do? Are you going to take the chance of going into jail for 6 months? The probation's easy. If you're a regular law-abiding citizen, I think the probation's easy. Having a felony, it's not a big deal, especially if you have a first offenders. But that's crazy. All right, let's go ahead and get into YNW Melly. So YNW Melly is back in the news because he recently, in the past 24 hours, was back in court. Now, there wasn't any video available for it, and I was actually able to find this over on Law and Crime. So shout out to Law and Crime. I will leave a link to the full video in the description. But he's back in court. They're trying to figure out what's going on. What's the holdup with this trial? Judge Fein is getting sick of sitting here and things not moving forward. I don't blame him. Again, this poor man has been in jail for over 2,000 days, just waiting a proper trial. I don't know why he wouldn't get bond after this point, but the legal system is what it is. So before we get into the actual video of the court proceedings, I want to do a little bit of a rewind and give you guys an update what's happened over the past couple of weeks. And I also want to give a shout out to, let me make sure I say it right, Bryson Paul over on X. Shout out to Bryson Paul. I will have a link to his X account in the description as well. He's been following this case very closely and constantly giving updates. So it's a great place for y'all to follow. I follow him on X if you want case by case, instance by instance updates for this trial. So first we have YNW Melly's ex-girlfriend. She got picked up. Bryson says his ex-girlfriend, Mariah Hamilton, was detained, and this was about 2 weeks ago. She was detained, obviously, in connection to what's going on with this trial, right? Then Judge Fein, several days later, he ruled to release her from jail on Friday in an emergency hearing, but she's going to have to wear an ankle monitor, all right? He also says Hamilton agreed to sign a written promise that she would appear for all future court dates and stay in touch with her attorney and prosecutors. So there's that. Then, as you know, we've been covering what's been going on with Raven Liberty, right? Raven Liberty, she had some issues with YNW Melly. Well, not with YNW Melly. She had some issues during this trial. She was being accused of doing certain things, tampering with evidence, like giving communication back and forth between YNW Melly and other people. And now we found out she was being investigated. And the way she found out she was being investigated was she got an email from Apple, and they said, hey, Raven, by the way, we just wanted to let you know someone got a subpoena to access your iCloud records, and we wanted to let you know about that. Raven found out. They went to the judge. They had a hearing about it, and Judge Fein said, you guys need to let Raven Liberty know and let YNW Melly know specifically why you had this search warrant out on her iCloud account. So there's a lot of back and forth. The state said, Judge, we're not going to give you that information. The judge said, yes, you are going to give me that information. The state said, we really can't because of the nature of the investigation. All right, so they moved all of that forward. Judge Fein stood 10 toes down and said, you're going to do it. So now they finally have an update on that with Raven Liberty, and we're going to find that out in a second. But also, Raven Liberty, she also shared the following comments on Mariah Hamilton's release from Judge Fein. She said, Melly and myself are very happy that Miss Hamilton, who did nothing other than be my client's first love, is going home. So they commented on that. And then when she was released that day, they had the emergency hearing by Judge Fein. After she was released, says Bryson, Mariah Hamilton would acknowledge her family and friends who supported her while she was detained on a Facebook post on Sunday. And then the post reads, and to my village, thank you, my village. Love y'all so much. God's plan, not mine. All right. So she's released and she's going to be back in court. Now, here's the update on Raven Liberty, and shout out to Bryson Paul for this. He says Raven Liberty is under investigation for witness tampering and directing gang activity. All right. Golly. This sounds similar to some of the things that were going on in the YSL trial. And we're going to get into that tomorrow. The investigation stems from the unmasking of Detective Danny Polo during the original Melly trial. Polo was brought in to testify as the state's witness. He took the stand wearing a black mask with the purpose of keeping his identity unknown to prevent threats on him and his family's life. He would be unmasked during the testimony after a photo of him unmasked was discovered on his wife's Cash App account. Issues by the Broward County Sheriff's Office. The 10-page search warrant claims Liberty's Apple iCloud account records was obtained and reviewed by the state to gather evidence related to the alleged criminal activity. So they finally gave the information that Judge Fein ordered them to. The investigation included the search for the following: any images or references to Detective Danny Polo and his family, any searches for realtors as it relates to Detective Danny Polo. That's interesting. Any searches for Cash App as it relates to Detective Danny Polo and his family, any searches for Jacob Cherry, better known as 1090 Jake, and any reverse phone number searches for Detective Danny Polo or his family. Criminal investigation has YNW Melly in the position to choose if he would like to move forward with his legal team for retrial. And again, this is all not holding up, but it's all delaying moving forward in this trial, which has been a mess in the first place because this is a retrial, right? So we won't go through all the warrant. I can leave a link to this in the description for y'all as well. All right. Then moving forward again, we have more things happening. YNW Melly's mother gets involved in this somehow. In a 2-hour deposition in person, YNW Melly's mother, Jamie King, is set for a May 5th in-person interview. According to a filed notice with the Broward County Clerks, YNW Juvie estate, represented by his mother, Leandra Phillips, attorney John Phillips, and YNW Sack Chaser estate, represented by Edward Holodak and attorney Aaron Papero. King is among the 10 defendants named in 2 wrongful death lawsuits. And then last but not least, we're going to get into the proceedings that happened in court, and we're going to hear what Judge Fein's trying to tell both sides, what they need to do and how they need to move forward. So let's go ahead and get into this video. This is wild. Let me know if the sound is good too. There's YNW Melly. Libby says she's scared of him. He's young, man. Let him live.
Okay, I'm gonna go back on the record. This is on the top of my page 3. State versus Vermont. It's 941-872 CF10A. I've got Ms. Collins, Mr. Griffiths present for the state. I've got Ms. Liberty, Mr. Adelstein, Mr. Aronson, Mr. Benjamin. Present for Mr. Devon, who likewise is present. So today was on all pending motions based on our last discussion, the last time we were all here. I had asked that each side just set through notice of hearing as to what motions you want to read here. The only notice of hearing that I can find that was filed by Ms. Liberty.
There's Judge Fein.
February 8th, 2025. It was 8 motions. Number 1, defendant's motion for order to show cause to the state of Florida's ongoing willful and flagrant violation of court dated February 9, 2024. 2, motion in limine to exclude James Howard for relevant and immaterial detention communication calls. 3, motion in limine to exclude a relevant and immaterial TikTok video of meat page. 4, renewed motion to take deposition of Christine Bradley. 5, defendant's motion to strike from the alternative response to the state of Florida's motion to allow former testimony of Felicia Holmes. 6, motion for scheduling. 7, amended third motion to compel forensic images of the proceedings following. And 8, motion to compel. So that's what I wanted to get done today. State, I'm being told that there's a medical issue with Ms. Buckley, is that correct?
That's correct, Judge.
Okay.
She's on her own.
And what's your position as far as what you want me to do today?
Judge, the other issue we have, and I wasn't present for the hearing Friday afternoon, but my understanding was the court set a notice of hearing deadline for Friday 5 p.m. It was moved to Friday 9 p.m. because Ms. Liberty was stuck in court and needed time to prepare it. The notice was not actually filed until Saturday, so
Oh,
they
come
failed
on,
to
man.
comply with the court's requirements. So at this point, the state's position is no notice of hearing was properly filed and there's nothing to be heard today.
So you want me to do anything?
This also might have been covered by that.
Defense, Ms. Liberty, what do you want me to do?
The funny thing is, the great thing about this cameras in this room is everything gets recorded. I did say Friday at 9, and then I actually stepped back because I knew I was setting myself up for failure. And I said, well, I do it Saturday. Taylor then responds, oh, as long as we get it before the beginning of the next business day, which is Monday. So they've had it. Most of these motions, Judge, were filed for over a year. I will bring the court's attention, because last night in preparation of this,
More BS from the
I know the
state.
last time we were before, they objected then about hearing motions because they were filed under the tampering case. Yet they've filed several different motions saying it doesn't matter what case number are on the motions because the discovery is interchangeable. I'm quoting exactly the language from their own motion. So it's
That's
good
crazy.
for them when it's convenient, and now it's not convenient, so there's another excuse. It's been a year. Everything was properly noticed. I will also add, there's no written order setting a filing deadline or allowing them to file a response within a certain time frame. That was oral. So as we all know, oral orders don't count for anything. They need to be written. There was no written order. I did
Hey,
ask
she looking
the
him dead in the
Senate.
eye,
We are ready
too.
to
Get him,
move
Raven.
forward. There are 2 state attorneys sitting over there. Understandable. One of them is missing. Mr. Griffiths, is there something funny?
There'll be no attorney.
Ms. Liberty, you can direct your comments to me.
Okay.
All right, y'all
So
have
we're
5
ready.
years to talk to each other about this.
We're ready
You
to
just
go for
started.
it, Judge.
Okay. Listen, State, I get what's going on. I'm not going to put anyone else done here, but I read all this and I went through the entire court file in preparation for the hearing today. Most of these are fairly straightforward. Over your objection, I'm going to hear them, but if we get to some specific factual issue that you say only Ms. Buckley has the particular knowledge to address, you can certainly tell me that. But again, I find most of these to be very straightforward.
Shout out to Judge Fein.
So that's over the state's objection. So, listen, let me just do them in the order. That they're noticing.
This man
Number
is
1,
not playing around
defendant's
either.
motion for order to show cause why the state of Florida should not be found in contempt for ongoing willful and flagrant violation of court order dated February 9, 2024. I did read the motion on all of these. I read all the motions. If there wasn't any authority cited therein, I did review that as well. Ms. Liberty, I went on CMS yesterday and I went on Odyssey. I can't find any court order dated February 9, 2024, nor any order that you referenced on a motion for rehearing February 16, 2024. So if someone could show me those 2 orders. Okay.
The other one is, I think I may have put it in the motion, that you see an order from the homicide, they take the appeal, and I believe it was late December, so then you see orders coming from the tampering case, so that might be where the confusion lies, is there was 2 motions for rehearing. I filed the motions to compel, we came into court, the court had ordered that they comply with it. They filed a motion for rehearing. If you want, I can pull it up on the tampering case, because more than likely where it came from.
Is that what it is? I mean, I can pull it up. Are you telling me it's not in 1972 CFN?
Yeah, and that's kind of why initially I had this filed under 2022 3 because it would be easier for the court to file the state objected one and everything filed under 2019.
And I want to actually take a quick break here because I know some of y'all may not have seen this video from the alleged shooting, but let me play this back for y'all real quick. So we're going to take a quick detour, and it's just going to be a 2-minute video. So y'all check this out in case you haven't seen this. This case is taking place in Florida. Let me see if I can get it to look. Y'all see Melly?
Excuse me, you're able to see?
And this is from the first trial. Yeah, it's Melly in the purple shorts right there.
Detective Bertrand, in your experience in collecting and reviewing surveillance footage over the course of your career as a homicide detective, is the time always accurate?
No.
Is it your...
All right, so that's the video where they're alleging everything initially went down or where everything started. As y'all can see, take that for what you will. Then there's an alleged drive-by, and they're saying that Melly was actually the one that shot 2 of his friends in the car, and they're basing that off of where the bullets are seen, or where the ME is saying the bullets entered and exited, and that's why we're here. There we go. We'll get to it.
Or we can take that one last and I'll take a break and then pull everything upstairs there.
No, give me a second.
And the retrial is scheduled to begin on September 10th. Yep, so he's going to be in there another 7 months. Let's skip ahead here. Getting their stuff together. There we go.
It says this call. So I found the order. This is the case number 23-105946. Judge Murphy entered an order on February 9th, 2024. It says this cause came before the court on the defendant's motion to compel discovery filed on February 6th, 2024. When the state filed a response, the court held a hearing on February 9th, which granted. Judge Murphy subsequently entered an order denying the state's motion for rehearing. That's on February 16th, 2024. There's only one motion to compel from the defense filed on February 6th, 2024. And I'm looking at it right now, I just read it. And I don't see any reference to the 4 items that you put in the present motion.
Would you look and see if there was not another motion to compel possibly a day before?
Well, I'm just looking at Judge Murphy's order. He said this order is related to the motion to compel discovery filed on February 6, 2024.
So there's actually,
That's the only motion to compel filed on February 6, 2024.
so there should be 2 motions for rehearings filed by the state going to 2 separate orders, and then the judge denied both of those 2 separate orders. So there was 2 motions to compel, and I believe in the one motion to compel, it was going directly to the information regarding.
Hopefully time served will factor in for Melly at some point.
Well, did Judge Murphy enter an order on that?
Yes. So if you want to pass, I'll pull it all up so we can read it and make it a little bit more easy. I'll pull it up and read it. Go along quickly. But there were 2 motions to compel, and there were 2 motions for rehearing.
Was there 2 original orders?
There should be 2 orders.
Okay, so we'll pass on that.
So the next one would be James.
Look at this guy.
Yes. Number 2 is defendant.
That reminds me of somebody.
To exclude James Howard's irrelevant and immaterial detention communications. So you're talking about, this is a motion limited for trial. And I read the motion. Anything else you want to tell me to support your motion, please?
This judge, it was close to, I want to say 84 hours worth of phone calls that were given to us that December. We were set for trial. I was always of the position it was given to us that late in the game in order to make it continue it. Nonetheless, I had a group of students go through those phone calls along with myself and the investigator. When you look at the police report that was authored by Garrett Steele, it starts referencing a investigation that's being done by Danny Polo into this James Howard, and I believe the Albany. He, for some reason, then references James Howard in this police report, saying he was listening to phone calls by James Howard, and then he hears James Howard telling somebody on the phone call that he has to do something from Melly that day. We had the opportunity to depose Detective Polo as well. I asked him this very question. I told him over 80 hours worth of phone calls. There was one phone call, and that one phone call in this batch of phone calls tells us nothing other than him saying, "Oh, I have to talk to Melly today. Now I have to do something for him. Now I got to call people for him." Nothing at all. During the deposition of Detective Polo, when I started questioning him, "Hey, I went through all these phone calls. Could you please direct me to what phone call I should be looking at? What batch of phone calls?" He then tells me, "It's not this batch of phone calls. It's a batch of phone calls that would go back to 2020 and 2021. We are dealing with the tampering. I believe we're spanning from April of 2023 until August of 2023, somewhere in that time frame." Detective Polo, in his own words, was the only time that he had heard James Howard talking about Melly, would have predated the incident, i.e. 2020, 2021. Nonetheless, those phone calls are not in this 84 hours of phone calls.
Yeah, the board could see on that, there is still the outstanding issue of whether Mr. Dennis still wants to still be representing him, the state to raise the issue of the conflict of interest. The court pointed that out. That was going to be one of the first things we were going to address today. And
Dang, he's taking shots right off the bat.
I mean, that's his call. I already had that discussion. I'm sure if there's something that you want to let me know, you're going to let me know. Any response to the motion?
Yes, sir. The state filed a written response, I believe it was yesterday. This is one that's properly prepared.
Yo, he straight up just looked this lady in the face and said, "Judge, I don't even know she's supposed to be here. So, are we gonna deal with that, or what are we doing? Because I don't know. I don't even know why this chick is talking. That's wild."
In this 84 hours of phone
state can respond.
Yeah, before we proceed on that, there is still the outstanding issue of whether Mr. Dennis still wants to still be representing him. The state has raised the issue for the conflict of interest. The court has pointed that out. That was going to be one of the first things we were going to address today, and we still need to address that because obviously if he does not want Mr. Liberty representing him, then there's an issue that can argue the motion.
I mean, that's his call. I already had that discussion.
The sound should be good. Do y'all need me to turn it up?
Any response to the motion?
Yes, Judge. The state filed a written response, I believe it was yesterday. This is one that's properly prepared, but as pointed out in the argument, the state is not required to disclose which calls it intends to use at trial. But other than that, we are going to rely on the responses.
So I did check the docket this morning. I thought no written motion. And it's funny, Judge, that they were starting this hearing off saying they wanted to continue it because they didn't get proper notice. A notice of hearing from, I don't know, almost 2 weeks ago. But in the evening, they filed something before Ms. Buckley went to the hospital.
This is the second time. You need to look at me and address things to me. I could give you a lot of adjectives about what I think of this entire procedure. Funny is not going to be one.
Okay.
So anything else you want to tell me about this?
Dang.
Judge, I would say there are no
Court is very low.
that would go to the nexus of witness suffering.
Okay, so this one, and I'll enter the appropriate order to be denied without prejudice. I have no idea what is or what is not going to be relevant.
Judge Fein is fed up with this.
Evidence at trial. There's no way that could. I can't make the state try to case in vacuum. But there's, without prejudice, you can certainly raise the issue. If the state tries to introduce any of these phone calls at trial, give the appropriate objection, and I'll give you the appropriate ruling. But in a vacuum, having never heard any of these calls, I have no idea what the calls are, nor do I have any idea what the evidence is going to be at the trial. So that one's going to be denied without prejudice.
So, Judge, I had for the state of the court of Fein emailed and asked your chambers how you want to proceed with some of these videos. So the next one would be a TikTok video. We can show it, or I can give it to chamber sets, but I didn't know, so I couldn't pass. We usually have provided it, and then you watched it.
Well, listen, I'll let you argue what you want, and I'll let the state respond if they want, but for all of these, it would be the same thing. I don't know what the evidence is going to be at the trial. There's actually already been a trial, and the evidence may be the same as the first trial, or it may be completely different. I have no idea. But I can't make a decision now without there being one witness, without being one piece of evidence, without hearing the answer one question in anyone's testimony. You may be right. These things may be not relevant, and the state may not even try to introduce them. But I can't give you a pretrial ruling, again, in a vacuum when I haven't heard it.
So how would you, I'm just curious, how should we proceed? Because we have to do the pre-trial motion. We are seeking for pre-trial rulings to keep out certain evidence that's not relevant. So the next one on here would be a TikTok video, period. We're dealing with, i.e. homicide.
Fighting over a TikTok
is
video.
after the homicide. I don't even believe the individual in the video, which would be, and excuse me, I'm going to see her name, Geneva Molina, doesn't even know Mr. Dennis. So there is no relevancy to the homicide and my client. If it was filed, I guess, because they have it interchangeably with the tampering, there is, I guess the tampering was used would be Mariah Hamilton. There is no evidence in that video of Mariah Hamilton. There is no evidence in that video of anything, period, that has to do with this tampering case or this homicide case. I believe it is the state's burden at this juncture. It's not our juncture. It's not relevant, period.
I don't agree with you. It's not the state's burden. This isn't the trial. So, state, anything you want to tell me?
No, we would ask Dr. to defer ruling depending on whether or not it comes out of the trial. Depending on the evidence, it may become irrelevant once I provided, and we can't tell you at this time that at least we can't say we don't. We provide it to defense, and should it become relevant in trial, it will be subject to all appropriate relevancy of the action, and we can address it then.
Thank you. So for this one, I'll enter a written order. Again, the defense motion is denied without prejudice. Certainly you can bring up whatever appropriate objection you need to at whatever time.
So he's letting the video in.
If the state ever tries to introduce it at trial, maybe they will.
So
that's number one.
just to make sure that I'm following the court's ruling, and if it comes to the trial, should I then file a renewed motion eliminating so it can be argued in trial, or will it just be readdressed at trial? All right.
Number four, renewed motion to take the deposition of Christine Bradley. I did read the motion. Anything else you want to do?
I would just say Judge Murphy had already entered that order, which I attached December 18th. And it says, after such emails are reviewed, if the defense still wishes to depose ASA Bradley, counsel shall file a written motion. So I did that. I did sometime in February, close to a year ago. I wrote it out. At this point, we need to depose her, especially in light of all the things that came up. I went through and I amended this motion to add a few other things that had happened in the deposition, i.e. these emails. They get even more confusing. Your lead detective on this case, Garrett Steele, said under oath that he
Yes,
never
there was
read
a
these
mistrial on the
emails.
first
These
trial.
emails are referenced throughout the affidavit and the arrest, stating that the deposition and these emails prove there was an official proceeding that Mariah Hamilton did not go to. Again, Garrett Steele said he never read the emails. Danny Polo then says it's not his case and he can't comment on the emails. It's really unclear from reading them what's happening. And again, there were certain emails that were not even provided by the state that we later were given from other sources.
State your response.
First, that's an inaccurate statement. The emails were actually provided. That's actually in the state's response to one of Ms. Liberty's other motions, returning specifically this one. The state filed a response back on January 2nd, 2020. We're relying on that response.
In the 19 days
In the 19 days.
Give me the exact date.
Copies furnished January 2nd, 2024.
So, State, let me ask you this. Is Ms. Bradley listed as a witness?
No.
She's not. You have to call it.
No.
Yes, she listed by you all as a witness. So, the defense is a witness, she wants to rule, and you intend to call her.
Yes.
So, you don't know what she's going to say, but you intend to call her as a witness.
We do intend on calling her as a witness because she has, I believe that because as far as, or correct me if I'm wrong, as far as the other issue before she testified, anybody, no, all right, she wasn't there. I want to
Tell me what you need to,
It's very
give me a couple questions you want to ask her.
I wanted to get to how, what other emails were there that she had between Christopher Barris, showing the efforts to get Mariah Hamilton to this deposition.
So with Ms. Hamilton, that's the person who just got put on an ankle monitor.
Yes.
So let's say Ms. Hamilton now shows up and testifies. So what's the relevance of any of these other stuff? She's going to be here, she can be subject to examination, cost of
Because we still have a witness preventing the tampering, we have to get to the bottom line, which means that the arrest report is referencing April 18th. It's going on to say that they looked at emails provided by Ms. Bradley that show these efforts to get her to this deposition, which is weird because we don't have those emails and any efforts to get Ms. Hamilton to a
More
deposition.
BS by the state again.
We need some clarification from the previous state attorney when you talk about these efforts to get her to deposition, and then we are provided emails, and those emails tell us something totally different than what's being
Is Ms.
brought
Bradley
before.
listed as a witness in the 23 case? Is she listed by you as a witness in the 23 case?
Not at this juncture, Judge, this was the appeal before we got that far. And this, again, was a motion that was pending, coming up to getting as
Well, do you want to ask her questions about the homicide, or do you want to ask her questions about the tampering?
about the tampering.
And she's not listed as a witness in either one, by either side in that case?
Okay. So with the tampering, this motion had initially been filed. We hadn't got to the point where we were going to do, I had not did a witness list yet on the tampering. She is listed, however, on the homicide.
You?
Yes.
Do y'all think Melly is going to keep Raven on? Or all of them on?
So Judge, the rules provide I can take depositions of
What do y'all
anybody
think?
with relevant information, which Ms. Bradley is, whether she's
Yeah,
listed
I agree.
or not
What do you
listed.
need?
Because they filed a protective order and won't allow me to do it. That's why I had to then file the first motion.
All right, so Mr. Groves, I'm looking at 3.220 subsection H, discovery depositions, and this is 1A. The defendant may, without leave of court, take the deposition of any witness listed by prosecutors in category of witness or listed by a co-defendant as a witness to be called at a joint trial or hearing. That's not Mr. Bradley in this case. But then the next sentence says, after receipt by the defendant of the discovery exhibit, the defendant may, again, without leave of court, take the deposition of any unlisted witness who may have information relevant to the offense charged. So don't they get to take your deposition?
Except for the fact that she is a state attorney, and her role as state attorney, she is entitled to protection to file a protective order, in part because everything that Ms. Liberty is asking for has been turned over. Emails, whatever else that she's been looking for, has been turned over. I believe actually several times by Ms. Buckaloo, again, which is one of the issues going forward today, not having her here, but she was the one providing copies of everything.
Well, she's not assistant state attorney assigned in this case.
Ms. Bradley? No, she's still, it's no different than if somebody is a case filer or works on a case. There are work product protections involved in terms of what Ms. Liberty intends to ask. And we sought that protective order because she's entitled to those protections as a prosecutor, and also because, based upon our response, that it is unnecessary. I'm sorry.
Did someone grant the protective order?
I believe that was a hearing that Mr. Klinger conducted back in like November of last year, but I was not party to that.
So that's where we get this order coming down on December 18th. And then Ms. Buckley was ordered to provide emails, and if I was not satisfied, as that order clearly states, write the motion so I could depose her. So if I've written the motion, I am looking at what she provided.
I guess last word, Ms. Liberty, I'm still not following what the relevance is. Tell me what, let's say she wrote 1,000 emails back and forth. What is the relevance?
Because if you go to the arrest affidavit, under the witness tampering, these emails that Ms. Bradley authored are specifically referenced in Garrett Steele's police report, right? He says that he reviewed emails between Christine Bradley and defense counsel coordinating the deposition of Mariah Hamilton, that she showed her numerous attempts to get Mariah Hamilton to this deposition. That is Garrett Steele's words. We deposed him. I put it in the motion. Garrett Steele then says, I never read a single email. I'm depending on him.
His report's not going to be in front of the jury. I mean, none of that's going to be in front of the jury.
I know, Judge, but when I'm moving to set up every element of this witness tampering case, it seems more and more that it was filed out of being vindictive, more so than anything else. It is relevant to these emails because it is part and parcel of everything of the basis of arresting Mr. Dennis. They weren't saying Mariah Hamilton didn't show up to trial. They said Mariah Hamilton didn't show up to a deposition. The other reason I need to depose Christine Bradley, because it's really important how that May 5th date was given, all right? So when we're trying to go with the premise that my client tampered with Mariah Hamilton because she didn't go up to this deposition, we need to hear from Christine Bradley and find out what efforts she made to coordinate this deposition with Christopher Barris. That is why she was also supposed to turn over these emails. And guess what? When you read these emails that get turned over, Stuart Adelstein's emailing with Ms. Bradley, trying to ask for dates for the deposition. There was not one single email that was provided to us in Ms. Buckley's response from the time that Christine Bradley gives us dates to the time that Stuart picks up. She was not contacting Mr. Barris. That is, we can't see that at all from her emails. We finally get an email from her, April 18th, that's copying an email from April 17th.
So
that appears to
saying
be
you
the
can't hear
first
me.
email
Okay.
that she sent to Christopher Barris about this deposition. So for the
Should be
state
good there.
to not coordinate a deposition with a witness and then to cover up their negligence, turn around and file a criminal charge against the defendant. When in reality, if we got her up there, we would hear from Ms. Bradley that she never properly coordinated this deposition, that she never told Christopher Barris. And all the months leading up to us trying to schedule this, Mr. Barris, from these emails, was never contacted. And that's what we need to depose her about, the efforts that were made from her. There is an email in here also that was provided where she talks about numerous phone calls and text messages that were sent to Mr. Barris. I don't see those. We don't see the numerous text messages. We don't see the numerous phone calls. So we need to depose her on this limited subject of what she did.
Okay. So I just read the information in 23-1059-4CO10A. I just read the standard jury instruction 21.10, which is tampering with witness. The elements of the statement have to prove.
It's official proceeding. They don't prove it. I know that. I did the deposition of Garrett Steele. He can't even tell us what a subpoena is. He kept saying that's a lawyer word. When I asked him under the statute, tell me what official proceeding is. He goes outside of the statute and tells me anything that's involved with the lawyer, that's an official proceeding. That's your lead detective. They want to kill my client. That's what we're playing with his life.
Stop. Wait. You just told me this has to do with the tampering case. No one's getting the death penalty for the tampering case.
Yeah, but they want
Ms.
like...
Bradley's testimony in the murder case is wholly irrelevant. So
They want
let's go back.
prison.
We're talking
Come
about
on,
tampering
Raven.
case, we're talking about the
We are talking
homicide
about the tampering, but they're also intermingled with each other. So it's life in prison.
Okay, I got it. Respectfully, over the defense objection, the renewed motion to take the deposition of Christine Bradley is denied. So I'll entertain the appropriate written order. I don't find that her testimony would be relevant in any way, shape, or form. It's not relevant to a homicide case. nor do I find that it's necessary under what's been followed in the tampering case, the information or what's required for improvement pursuant to the jury instructions. But you're telling me you listed her as a witness, that means you have a good faith belief that you're going to call her as a witness, so you're going to call her as a witness. That's where the questions you want from the jury under oath.
Oh, sorry, y'all.
Next, number 5 is defendant's motion to strike.
Judge, can I just ask for a finding of fact when you write that over, please?
Everything that's stated on the record.
All right.
Defendant's motion to strike and or in the alternative response to the state of Florida's motion to allow former testimony of Felicia Holmes. So this kind of mirrors the same as 2 or 3. I mean, I have no idea if Felicia Holmes is saying she testified at the first trial.
Testified at the previous trial, Judge. We actually started to address this motion at the previous hearing when Judge Murphy, Ms. Palestine actually put a stop to it because he brought up the issue the court has brought up, which is until she actually takes the stand, we're not outside the presence of the jury. We're not actually going to know what she's going to do. She has filed through her attorney a notice of her right to invoke her Fifth Amendment privilege. And I believe when she was in court, she was either going to say she was going to invoke her Fifth or say that she didn't remember. But I think what's going to end up happening, as Mr. Adelstein suggested at the previous hearing, once we get her as a witness at the trial, she'll be brought in outside the presence of the jury, and then we'll have to come up the inquiry.
So you want me to defer on this until we have a proffer from her?
Correct.
Okay. Is there anything else you want to tell me about your motion to strike, or in the alternative, you want me to consider it as a response?
I wouldn't
If the
consider-
state does at some point ask to allow her former testimony, which I guess you're not asking at this point.
We obviously anticipate her invoking or saying she has no memory, but until it actually happens, I mean, she might not show up, which is another issue, which we might then saw.
She's on a bracelet, Judge, to show us where the other arrested.
Okay.
Right, but until we reach that point.
Anything else you
Yeah, a lot of them are on bracelets.
As I put forth in my motion to strike. Actually, Ms. Bradley filed it, they incorporated it, they have not withdrawn it, so it's their intentions to move forward. Mr. Griffiths is correct, she does have to show up here and testify. That's why I put that email there that Ms. Bradley sent. And if you actually look at the response to Ms. Buckley was supposed to turn over all these emails, she never included that email conveniently. But that email I sent the day before this motion is filed, saying what? I've done all the research, and from my research, it shows that Ms. Holmes would have to show up to court and plead the Fifth. I'll file the motion if she shows up to court and pleads the Fifth, and then she doesn't have to come back here anymore. I find it disingenuous and unethical for the state attorney to be advising a witness to plead the Fifth on the stand, much less advising them how to testify whatsoever.
Did she have her own lawyer?
She has her own lawyer, Mr. Barris.
You're not going to.
I'm certainly not giving her any advice. So.
But that is Ms. Bradley.
Ms. Bradley is no longer
Ms.
the
Barris,
attorney.
but you are moving forward on her motion. So that is Ms. Bradley telling Mr. Barris that your client needs to show up and plead the Fifth. So now Mr. Griffiths is saying, oh, we are going to move forward, but she needs to show up and she needs to plead the Fifth.
Yeah, they know how to pronounce his name.
If it's his intentions and he knows that she's going to plead the Fifth, it's not proper to bring that up in trial or in front of the jury.
Well, I agree. I mean, that won't happen in front of the jury. If I don't remember it on my own accord, I'm sure you all will remind me, and I'll send the jury out. We'll bring her in outside the presence of the jury for her oath and see what she thinks.
So what it sounds like is he's actually agreeing, judges. They're not going to be moving forward their motion to have her deemed unavailable. They have plan on having her come to court. So I move this right to motion because that's what they're saying themselves.
I'll defer on your motion at this point. It's not granted or denied. There was a name pending. We'll deal properly with Ms. Holmes at the appropriate time. I'll let you decide argue whatever they want to argue and take it from there. Maybe she'll just decide to answer everyone's question. Okay, number 6, motion for scheduling order. So I read this, and I also did review
this
it
one's
in,
kind of wild.
3.220 subsection H, the discovery deposition. And I quote, a party taking the deposition shall give reasonable written notice to each other party and make a good faith effort to coordinate the date, time, and location of the deposition to accommodate the schedules of other parties and the witnesses to be deposed. The notice shall state the time and the location where the deposition is to be taken, the name of each person to be examined, and a certificate of counsel that a good faith effort was made to coordinate the deposition schedule. So at the end of the day, I consider this more of a professional courtesy. If the parties want to be courteous to each other,
It should be simple.
That's always kind of preferred, I guess. But if the parties don't want to be courteous to each other, you don't have to wait for one state attorney to tell you set the deadline. Mr. Devins has now been in custody for 2,202 days. Okay?
2,202 days.
This case can stand in, and if all 3 are not available, maybe one of the other 100.
That's so sad, man.
But you don't have to wait on that. So.
Thank you so much, Judge.
I mean,
just so you're clear, you're not advising Ms. Liberty unilaterally set the motion.
well, it's not unilateral. She can coordinate.
With us.
If I'm getting, I read the motion. She says she's. I mean, I had one state attorney who could tell me he's working 1 day a week here. Is that right? So that's 80% of the time is off the table, and it's being told that I can't show these dead roads. I won't do it. You don't have to wait. Set the depots.
2,202
Someone doesn't answer
days.
subpoena, file the appropriate motion, and I'll conduct an indirect criminal contempt proceeding. But it's time to move forward.
We are moving forward, Judge, but we also, the other issue has been is that Ms. Liberty must properly coordinate and must properly notice the state. This is a return. I know, but
I just read the rule. She doesn't have to coordinate anything. She has to make a good faith effort.
Right, she has to make an effort.
She has to put a certificate on the bottom that says, I tried, they told me no.
So what has happened in the past is that she has asked for dates, we provide dates, and then she schedules dates out
Thank you,
times
Sean.
outside of them.
Judge, he's actually lying to the court right now. I printed out every
Please.
email.
Oh, here we go.
Stop. She's gonna set her deadline. She has to put a certificate of good faith on the bottom. If you all feel that that has been submitted in error, you file the appropriate motion, and then what would be a wonderful use of this court's time is I'll have a hearing with 6 lawyers, 7 lawyers, because you all can't set that. So in case I'm not making my feelings on this point clear, I'm not prejudging anything, but talking to a judge about trying to agree to set depots in a death penalty case is absurd. And I'm embarrassed for both sides. I'm embarrassed. The motion for scheduling order is denied. You don't need a scheduling order. Set your depots. I'll enter the appropriate written order. Next, number 7. Defendant's third motion to withdraw the forensic images of the cell phones belonging to Christopher Thomas and Anthony Williams. I read this motion. So State, let me start with you on this one. Do you have anything from the cell phone downloads of Christopher Thomas and Anthony Williams that has not been turned over to the defense at this point?
Judge, again, this one is Ms. Buckley's purview, so she filed a written response back on. Sorry, May 20th, 2024. I think the issue that Ms. Buckley had, and I'm probably going to be speaking out of turn on this one, is that there are contents of the phones that are not relevant to the case, and so some items have been turned over, but not all the items. I am not. This is one where I am lacking in knowledge.
That's okay. The state doesn't get to decide what's relevant and what's not relevant. These are the homicide victims, right?
Yes.
Just turn over everything in.
Well, Judge, I can tell you, because I'm a part of it. It's not that
6 years without bond. Imagine if it was Rice Street.
We scheduled that. We told them they can come again. There were multiple days when we sat there waiting for their investigators, came out late.
She's waiting in. So I'm
If
gonna
I may
put
finish,
it
Your Honor, I was the one who was personally there that day with him and our investigator. We continue. Anytime they want to come see it, we have had an investigator from our office, the computer, and their investigator there.
Is this something where they can just stick a thumb drive in and download what you got and that's it?
Make a copy of it? No, Your Honor.
So we
Why can't they do that?
As Mr. Griffin said, Ms. Buckler was the one with the most knowledge of all the contents of the phone, and that's why it's all discussed in her response. But regardless, the state's obligation to make it available. We have and continue to anytime they want to
Let's make it
schedule.
available. One of the things
For
to make it
inspection.
available for is to copy it. They're allowed
If it's
to copy
available
it.
to be copied. Ms. Buckler, and that's why in this one of the motion, we said that she would be prepared to argue, is of the opinion that she
You
filed.
already went to trial. You
Exactly
already went to
right.
trial?
And it was
You already went to trial.
Yes.
This is the decedent's cell phone. Okay, over the state's objection, this motion is granted in full. Make the appointment, go over there, download everything that they have.
Get it done.
Oh, no, they have to copy.
Yeah, you gotta redo it. That's what the rule says. Available for copy inspection, so it's available for copy, so go copy it.
This is what my suggestion, because it's accelerated download, if they wanted to copy it, now I can have my expert come and do an actual rip of the phone then. And I
And they can write it down,
Can't you
digital
just
forensics.
copy what you have?
Yeah.
Don't you all have it down?
Right, their expert can do that, but if, as she suggested, she wants her expert, we can absolutely do it regularly. They set up an appointment with BSO Digital Forensics and they
Yes.
do a download with them, then
Or they
too.
can give me their download, I don't understand where I put it now, the first time I have to go to their office, to give me download, I never. They usually say, bring us a drive and we'll download it for you.
What do you want? So, which is your preference?
I will get my expert to do our own download
Okay.
of the phone. So where we need the parameters though, so when,
There's no
where.
parameters, just make an appointment. Listen, I'm not gonna make appointments for you.
Okay.
If you all can't work that out, I don't know what to tell you. Okay?
Well,
We'll appeal before DCA and say,
this is the
we
state
can't make
we're talking
appointments and treat
about,
each other like
Judge
civilized
Fein.
human beings when we have to come over and download.
We know how often they say, oh, well, we can't locate it. Oh, we didn't know what it is. Are you sure we didn't send it? We've seen this in every single trial we've covered here.
We get to download.
And I just wanted to make clear on
We
the
need to
state's
set it in
response that
stone.
Ms. Buckley filed, she would be one to argue that we're not prepared to argue does, and there are numerous times cited how that would be a departure from the essential requirements of the law based on all of the 10 pages that she filed. So
Listen, I understand. I understand. I reviewed your motion. It's a capital case. Again, I want to do the reading myself. It's a capital case. She's gonna download it. That's the rule. Last, number 8. The motion to conduct. Mr. Eaglesy, this is your motion.
Yes, sir.
I did read your motion. What else do you want to tell me?
I will rest on the motion other than to say to the court that under the rules, since it's related to the murder case, they are obligated to give it to us. And I think the court ruled that since defense counsel has not been charged or a defendant in the case, and they had this information for over a year and nothing's been done, that it does not qualify as an
It's been sitting for 6 years.
In addition to that, that they are obligated and they cannot hide behind the open investigation provision when it deals with information on charges against Mr. Demings, specifically the murder and the tampering case. And they've indicated that the tampering case is somewhat going to be used in the murder case, as I think they said, consciousness of guilt. Furthermore, I know the court has told us to talk to Mr. Demings concerning the potential conflict, and they have alluded to the conflict today. He doesn't know how to make that decision because he doesn't have sufficient information to determine whether or not he wants to keep Ms. Liberty or any of us on the case.
So they're still withholding information. It's crazy.
So-called pending investigation. I mean, it's now over a year. It's more like 14 months that they've sat on this information.
So, State, listen, for the most part, I agree with what Mr. Avison just said. You have a continuing obligation, so when you agree anything that comes from any source that is relevant to the charges against Mr. Demings, you have to turn that over, right?
Before we do, yes, Judge, there is an ongoing obligation for things relevant to his homicide or to his open tampering charge that would be turned over. Having said that, Judge, we weren't noticed for this particular motion today, and we would rather have a full response. The notice says motion to compel. We didn't actually receive this with this Liberty's pleadings. This one actually came separately, and we only received it, I think it was 2 days ago.
2/14 it was filed.
And I, honestly, it says motion to compel. Ms. Liberty's filed so many that we were unaware that this was going to be hard to
Okay, let me hold on that. Here's the last paragraph. Here's what Mr. Avison said. Affidavits, search warrant, police report, the name of any witnesses, and all witness statements related to the Apple iCloud account belonging to Raven. Before I ask you anything, all this stuff belongs to Ms. Liberty. Does she ask Apple to just give her a copy?
I believe her lawyer did write a letter asking for the return of all, and they said there was going to be nothing.
They're not going to give her her own thing?
Nothing.
So let me just, if
You asked for it and they told you no?
I did actually email, because when they let me know about this,
Wow.
they give you an email that you can address to them. I
So
sent
they're
them an
still
email. They
fighting
said, "Hey,
against
we
this."
told you, you have to contact your Broward Sheriff's Office to get anything done. So
Apple won't give you your own stuff.
They said Broward Sheriff's Office. Apple then did sit with me. I went through it. I have access to the iCloud, but no, they will not give me the return of what they got.
But you have access to the
Wow.
iCloud that has all your stuff on
Of course, that's just my iCloud.
it.
It doesn't matter. They have it in
No,
their
no,
possession.
listen, I don't disagree with you, but you all are a little more adroit in these technical matters than I am. There's nothing that's outside of what's in her iCloud. Everything's there.
I don't know. I don't know what they've seized, because I believe there are additional.
That's what
search
they've been
warrants
trying to
based
get.
upon
They've been
the
fighting
original
for a while.
Well, I don't know anything about that, but as
I
far as the
understand.
search warrant, I already ordered you to get that, you got it. As far as police reports, there isn't any police reports, right?
It's still it's still no investigation, Judge.
Here we
Well,
go.
I disagree with that pursuant to Florida statute, but there are no police reports.
There are no police reports.
Because nothing's happened. Okay, so there's no police reports. The names of any witnesses and all witness statements related to the Apple iCloud, that would be like a custodian of records, right? There's no other witnesses to iCloud except a custodian of
Yes,
records.
it would be Apple or the records custodian certification.
Have you listed a custodian of records?
There's nobody to know, Your Honor. We have not
You
listed
have not.
either the homicide or the tampering case.
So you would have an ongoing obligation to do that if
We
you
have-
wanted to use any of this.
We have an ongoing obligation to turn over anything that's relevant or may be relevant to either of those two cases. We are complying with our discovery obligations at this time.
All right, so affidavit, that would be, the defendant would be entitled to the affidavit, for example, if they wanted to file a Frank's motion, if they wanted to say that this was incorrect and the judge should have signed it. But Mr. Demings doesn't have standing to raise any of that. That would belong to Ms. Liberty. It's her stuff. There's no case involved, so I don't think at this point you tell the affidavit, but listen, this is what I'm gonna do. Go ahead, sir. I'll give you the last
I
one.
find it hard to believe that there are no investigative police reports saying they've contacted witness A, witness B to verify or to corroborate whatever is on, whatever they seized pursuant to their original search warrant. I find that hard to believe that in a year they come in here and file a motion indicating that Ms. Liberty must get off the case because of the conflict. I find that very hard to believe. And I find it hard to believe that they, in their investigation, did not take statements of potential witnesses. And they say it's interrelated to the murder and tampering case. So,
Well, I mean, they're in a continuing obligation, okay? If we get somewhere down the line and something is put before me that they had material that is required to be disclosed pursuant to 3.220 on February 18th, and sometime long before February 18th, and Mr. Griffith is standing here and telling me otherwise, he's gonna have a very large problem, right? A very large problem. So I'm not playing with it.
and I appreciate it.
So at this point, I have to take everything at face value. But that being said, I'm going to grant your motion in part as follows. State, I'm going to give you 20 days to turn over anything that you have received regarding the Apple iCloud of Braidwood Liberty. That you
Another
intend to
20
use
days?
At either trial, okay? And make it as detailed as you can, because if we get forward to the point of a trial, and they stand up and say, Judge, they didn't disclose this, and now they're trying to use it, you will not be using it. It will be barred as evidence at trial, okay? So that's 20 days to turn over anything in the Apple iCloud download that you expect to use at trial in either case, in Mr. Denham's case. All right, and I'm basically ordering you to comply with the rules, which you already should be complying with. So
They already should have done it. He ordered this a long time ago.
Otherwise, respectfully, is denied for the reasons that I stated on the record. At this point, there being no arrest and no charges and no case, I don't believe that there are any police reports. I don't believe she's entitled to the affidavit, and outside of records custodian, I don't believe that there's any witnesses or witness statements. But again, if that turns out to be something different somewhere down the line, I'll address that.
What about the affidavits?
I don't think you're entitled to.
If it's not a pending open investigation, and they're alleging certain things that supposedly deal with the tampering and or the murder case,
Right.
then we're entitled to that.
Well,
They should
just
have
turn
it.
that over,
Okay.
whether it's in the affidavit or not, whatever it is. He has to, as it relates to Mr. Demings, he has to turn it over. As if it only solely relates, if Miss Liberty, if they're, I have no idea. If they say Miss Liberty went and did X, Y, Z with witness A, I don't know how that wouldn't be considered as relevant to the case. If they want to introduce that in the trial, you know, then they're gonna have to turn it over within 20 days. So I think you're gonna have your answer in 20 days.
We'll see what the response is, and I'm sure we'll be.
So let me go back around to number
Yeah,
one.
we'll see.
Ms. Liberty, take your time. I need the motion to compel that was related to the order that you're now seeking to enforce. This is back on motion number one.
Okay.
All right, so hopefully we get some results from this. I'm not going to play the whole video. Y'all can check this out over on Long Crime. I'll leave a link in the description to this video. What do y'all think is going to happen moving forward? The prosecution has just been withholding everything that this defense has been asking for when it comes to something simple. Judge Fein said he already ordered them to give the affidavit so they can see and they can let Melly know what's going on, if he wants to keep them as counsel, and if we delay this even more. I find it highly unlikely this far along that he would, but it's his right, as they said in a hearing several weeks ago. So let me know what y'all think in the comments and in the chat. All right, we got a bunch of y'all in here showing major love, man. We're going to get to some breaking news here in a second, actually. Shout out to my guy, Sean. He's in here. He's begging me. He said, please cover this, man. So we're going to cover it. Shout out to my guy, Sean. He said trafficking, contracted, unaliving. We'll get into it. He also drops a 10 bomb. He says, I'm a fan. Shout me out, bro. Shout out to Sean Street. He said, my channel is starting soon. Y'all go and subscribe to Sean's channel. I appreciate you, man. He said, you're going to be the first to report, and I'm sorry. It's a Cali case, if I'm not mistaken. He also said, Viraj Patel. All right, let's go ahead and get into this. So I made some notes here. And let me go ahead and copy this, and then we'll actually see what is going on with Jay-Z. We got some breaking news for y'all. I know a lot of y'all have been following what's going on with Jay-Z or what happened with Jay-Z recently. Well, it looks like he's facing another lawsuit, and we're going to actually get into it. Now, I'm not going to read the whole lawsuit. I'm just going to read a breakdown of, let me see. I'm just going to read a breakdown of what's going on in the summary of the actual lawsuit. And then once I go through and really read if it's if it's worth it to actually get into the full lawsuit, we may do that. It's a little bit boring. So that's why I just came up with a quick summary here. All right, here we go. So let me zoom in. And then we'll break it down here. Got that. Boom. All right, let's get into it. So we've got this. And let me actually put this up here from the Diddy docket. And then I'll give you guys a quick breakdown. All right. So it's looking like Jay-Z is facing another lawsuit. I don't know what's going on, man. Somebody has it out for Jay-Z, or this was just the inevitable. I know a lot of y'all are saying you thought there was more to this whole Jay-Z situation than meets the eye. Well, we have another lawsuit here for Jay-Z. What's going on? We've got the Diddy docket here over on X. And what are they saying? In the matter of Patel versus Dorsey, Sean Carter has been sued. Jay-Z, A-Block Inc., a board member, is accused of SEC violations, breach of fiduciary duty, aiding and abetting said breach, unjust enrichment, abuse of control, and waste of corporate assets. All right, so what does that mean? Let's go ahead and break this down. I've got a nice little summary for you guys. Hopefully you'll be able to see all of this. I can actually move it around a little bit. And this will give you an idea of what's going on in this lawsuit. All right. First of all, this lawsuit is a shareholder derivative lawsuit filed on behalf of Block Inc., formerly known as Square Inc., alleging that its executives and board members, including Jay-Z, Jack Dorsey, and others, breached their fiduciary duties by allowing widespread illegal activities on the company's financial platforms, Square and Cash App. This is going to get ugly, but y'all hang in there. All right, so here's the key points you want to look at. Block's platforms were used for illegal activities. The lawsuit claims that Block facilitated money laundering, child abuse, trafficking, drug trafficking, terrorism, and financing and contract killings by failing to conduct proper customer due diligence. Okay, it's not saying that they did it. It's saying the platform allowed it to happen. All right, give me 1 second. So it's not saying that Jay-Z participated in this. It's saying the platform allowed for these things to take place. Y'all know Cash App. A lot of people like it because of how easy it is to move money. Well, they're saying there's a lot of things there. Misleading investors. The company allegedly provided false or misleading statements about its compliance with financial regulations and anti-money laundering laws, which inflated its stock price. And if you remember, the CEO of Cash App, unfortunately, last year, he was allegedly assassinated. Don't know if this has anything to do with it, but something definitely to point out. Failure to act on internal warnings. Executives and board members were allegedly aware of the internal red flags from employees and whistleblowers indicating these issues, but ignored them to maintain rapid growth. Regulatory investigations. Due to these failures, Block is now under investigation by the SEC and the Department of Justice, causing stock prices to drop significantly. So, sounds like a good opportunity. Sounds like a good opportunity if y'all want to get into Block or Cash App or Square in general. This might be a good buying chance, but we won't talk about that too much here. Financial harm to shareholders. As a result of these alleged misdeeds, shareholders suffered major losses when Block's stock plummeted following public disclosures of its compliance failures. So, how does this apply to Jay-Z? Jay-Z has been a board member of Block Inc. since May of 2021 and is listed as a defendant in the lawsuit. The lawsuit alleges that he, along with other board members, had a fiduciary duty to ensure the company was operating lawfully and in the best interests of shareholders. While it does not accuse Jay-Z of direct wrongdoing, which means Jay-Z wasn't the one that was money laundering, he wasn't the one that was involved in the trafficking. It's also saying that it claims that he and other board members failed to properly oversee the company's compliance with financial laws. They turned a blind eye. which is when you're dealing with finances, that's something that can really get you into trouble, whether that be taxes, whether that be messing with stocks. And there's a lot there, right? The lawsuit also points out that Jay-Z benefited financially as a board member, having received nearly $290,000 in compensation in 2023 and owning 38,073 shares of block stock, valued at roughly $3.1 million as of March 2024. Here's the potential consequences and what it's looking like Jay-Z may face. If he's found liable, Jay-Z and other board members could face financial penalties, including personal liability for damages accrued by shareholders. He could also be removed from the board if the lawsuit succeeds. The lawsuit could affect his business reputation, especially given his public image as a financial and tech entrepreneur. And here's the bottom line to summarize everything we just read. The lawsuit does not accuse Jay-Z of personally engaging in the illegal activity, which I mentioned to y'all, but it argues that as a board member, he failed to stop misconduct that harmed shareholders. The case could have a significant financial reputation consequences for him, depending on how it unfolds. All right, so that's the breakdown of the lawsuit. I'm going to have a link to the full lawsuit in the description of this video. Let me know what y'all think about this. Jay-Z, man, he just got a win over Tony Busby, just got this last lawsuit dismissed. In this case, it's seeming like he's more so, again, guilty by association. He's guilty because he was a board member. He's guilty because, as alleged in this lawsuit, the board knew what was going on and they didn't do anything to address it. And they turned a blind eye because it was helping to increase the profits of the company, which we know. You just can't do that. You cannot turn a blind eye. Somebody's going to find you. Somebody's going to get upset in here, just like Viraj Patel did and filed this lawsuit. So let me know what y'all think in the comments and in the chat. What's going to happen with this moving forward? Is Jay-Z somehow going to get out of this and be removed from the being named in the suit? Or is this something that he's going to be held liable for himself? Let me know what y'all think about this. Man, Jay-Z cannot catch a break, man. What is going on? You're saying Jay-Z is a flight risk now, allegedly? Oh my gosh. What else are y'all saying? Let me see these. We got some super chats in here. Shout out to Jay-Z, and she said it's a hard life. Oh no, my comments aren't showing up for some reason. Shout out to Jay-Z. She says it's a hard knock life for us. Shout out to Jay-Z. And then we've got Mr. Brown dropping the 2 bomb. Just showing some love. Thank you, Mr. Brown. And also my guy Sean Street in here with the 2 bomb says, boring, right? Laugh out loud. This is fire content. Yeah, this is good. This is definitely interesting stuff. I wasn't going to cover it today just because I wanted to wait and see, but I was actually able to get access to the full lawsuit thanks to Document Tings over on X. So if y'all haven't followed them, make sure you follow Document Tings as well. And I may go through and actually read the full lawsuit tomorrow. Tomorrow, we've actually got some things happening here in Fulton County. We're supposed to have a hearing with Judge Whitaker. We're going to start the ball moving when it comes to Young Thug getting his property back. So we should have a motions hearing for that tomorrow morning. I will keep you guys posted. If you haven't yet, make sure you subscribe and hit the notification bell so you don't miss any time that we go live or drop a new video, because y'all know we are here every weekday and I'm dropping videos as we go throughout the weekend as well. Wow, what a day, man. A lot going on. And y'all know we do not miss. So we're going to be here. Thank you to everybody that liked the video. Thank you to everyone that sent in the super chats. Like the video on your way out. And as always, you know what to do. Keep growing, keep pushing, keep it classy. We gone. Peace.